has been preserved through the ages. But if you look at technology and how we're advancing right now, this came out 20 years ago. The iOmega zip drive contained about 100 megabytes of data and owned the marketplace. People were backing up their information left, right, and backwards on this thing. And right now, you couldn't buy one of these off the shelf to access your data to save any court case in the world. You are literally relying upon a flea market like eBay to come up and preserve your data. And so the trap is that as we move away from these great traditional technologies that have lasted us for thousands of years, we're using efficiencies that may not preserve our data. And I want to give another example of this. In 2005, the Department of Justice bought 50,000 WordPerfect licenses. And they did this in a quote to say, because quite simply, our users require it to do their jobs. In the courts or among attorneys, it's the tool of choice for the legal arena. And this was Mary Eileen Donovan, the program manager for the Justice Management Division of the U.S. Department of Justice. What's interesting is New York courts still use WordPerfect to this day. If you go to newyorkcourts.gov and jump into their form section, right there on the far right is WordPerfect documents. And this is from the family law section. I don't know any person out there that could get a temporary order of protection from the family court if they were required to use WordPerfect right now. What we've done is we've created a system where we put data in silos. And a very well-known technologist, James Schofield out of the UK, has drafted what he calls his first law of computing. And he says, never put data into a program unless you can see exactly how to get it out, which is a great rule of thumb. You don't want to rely upon proprietary formats and databases, but what we're seeing over time, and what I think the WordPerfect and the iOmega disk examples illustrate, and this is Lenon's Addendum, is that the passage of time will make almost every electronic file format inaccessible. We're putting ourselves in a position where, unfortunately, we put our data into silos, but then we've set those silos on fire, bulldozed them into the ground, and salted the ground, and left a bunch of scorched earth behind us in our race to grab the next best software, the next best file format, the next best iOS system. How many of you right now are typing on an iPad, and how many of you can pull documents from 5 years ago onto that iPad quickly and easily and in a legible, usable format? Just think about it for a second, because that's the trap in which we're all falling, that the next product that we use is not necessarily something that preserves the information that we need from the past. This is especially a problem, though, for lawyers, because we have a duty to produce electronic documents decades from now. And so the document you produced this week should literally be accessible decades from now. And you think I'm joking, but let's take a look at New York in particular. Lawyers need to produce on-demand financials and trust records 7 years from the date of creation. But you also, and this is from the New York State Bar Association, have to produce original client files or original copies thereof of original wills, files involving minors or those under disability, so that could literally be 18 years from now, or the lifetime of the person under disability. Select real estate files, and if we look at real estate files within New York, those easily go back decades, and family law matters involving future expenses. These are all examples given from practice management guidelines by the New York State Bar Association. Their best advice is to use common sense and err on the side of caution, which seems to me to be saying, don't throw away anything, oh my, you're going to need it at some point. And this advice doesn't even take a look at statutes of limitations for malpractice claims, which in New York tend to be 3 years from the date of occurrence, but under the continuous representation idea, could mean that the lifetime of the representation and the actual occurrence of the event are vastly different in scale. And so to protect yourself, again, you're going to need to be holding on documents in a usable, producible format. If we jump across the pond and take a look at the Law Society of England and Wales, they give two very clear definitions of how long you should be retaining certain types of files. For trust, it should be the life of trust plus 6 years. And within the document in which they describe this, they're very clearly talking about examples where there may be a remainder from the trust that reverts after the lifetime of the life of the trust. And so then you have the lifetime of the trust target plus 6 years. It's almost a law of perpetuity happening right there. And with wills, they give you two options in their guidance. One is keep it indefinitely, and the other is some law firms keep it 50 years from the date of creation. But again, and this is an exact quote, you should be erring on the side of caution, which seems to me to be indefinitely at this point. And they even state you should be keeping a copy of a will even if you know it's been revoked, because if there's a dispute on a following or subsequent will, and that will is declared invalid, then the revoked will now come into force. And so you, as a representative of your client, need to be producing these documents decades from when they've been created. And in electronic file format, that can be a huge problem. We know that software changes every couple of years, and we're hitting a point right now where we've seen even iOS systems are becoming obsolete, with support for Windows XP being canceled after finally 12 years of security updates. And so lawyers who are relying upon software that uses proprietary formats that run on Windows XP are now going to be forced to either turn to, hopefully, some type of emulation software, or may not be able to access that software at all. Can you say your client's files are safe with you for the next 50 years? And if you can't answer that question, then you've created a problem. And the current solution to that problem is warehouses. Warehouses of boxes and boxes and boxes of paper, which does not jive with the idea of increased efficiencies and means of serving our clients that become better suited towards our digital lifestyle. And so I've been researching this quite heavily, and I think the answer is that lawyers should be using approved document standards to ensure access over the span of decades. And the question of where to grab those approved document standards is really still somewhat up in the air. There's only one real place to turn to for this right now, and that's the International Organization for Standardization. Since the 1940s, they've been coming up with worldwide proprietary industrial and commercial standards out of their headquarters in Geneva, Switzerland. And a good chunk of the time, this applies to mechanical processes. So we see a lot of different gauge standards coming out of here and measurement standards. But they do have a couple of standards for document and knowledge preservation that I think should be becoming the basis by which lawyers and law firms preserve documents for the next 50 years. And those three standards are ISO 1905, ISO 29500, and ISO 9075. They relate to three things that you're probably using right now, but you may not be using them to the full degree that you should be to preserve your client's information for the future. Let's take a look at the first one, ISO 1905. You'll be familiar with this as a PDF-style document, but it has a couple of key factors included in it that you may not be using, and the first of which is embedding your fonts in the document. And most of us don't do this for one simple reason. It makes for a much smaller file size. But if you're not embedding your fonts in the document, then what that document is doing is relying upon an outside file to control its presentation and formatting. And that may not exist or be accessible 2, 3, 5 decades from now. So under ISO formats, you should be checking the box that says embed fonts in this file. And the second thing under this ISO standard is that there is no encryption allowed. And right now, with all the talk of the NSA and Edward Snowden and snooping that's going on within a lot of the legal space, the idea that we should be foregoing encryption is actually somewhat controversial. But when you think about this, encryption of your file is the means of locking away access from it. And if you are the only person who has the key to unlocking the encryption of your files, what you're actually doing is preventing your clients from having access to that file at some point in the future, potentially, either because you no longer have access to the encryption software, you no longer have access to the key, or your clients may have access to the file but not have access to you. And if you are locking your files away, you are creating a situation where you are violating your ethical obligations to provide access to these files in a format that is producible and usable by the courts and the clients. If we take a look at the second standard, this one is controversial in its creation, and that's the Open Office XML standard. And it was created by Microsoft and kind of pushed upon the standards community. And it's actually against some other open standards that are out there right now, like the Open Document Format or ODF format. What's interesting about it is it's based on XML architecture. That's an extensible markup language. It's pretty much the exact same language we see being used to create types of web pages, for example. What's interesting about this is lawyers have access to this file format now, but for the most part, law firms aren't using it. We're all saving it in an older format, the .doc or doc format, when we should be saving all of our documents right now into this extensible markup language. And so we should be using the ending .docx. The X is for XML. And if you're not saving your documents in these formats, then again, we're going to be seeing decades from now, depending on the next brand of software that becomes popular, whether it's an Apple product like iWorks or a cloud-based product like Google Apps, they may not be able to open these documents, and you've suddenly spent a lifetime preparing yourself for a malpractice claim you can't defend yourself against. The one thing that neither of these options really deal with, though, is numbers-based. And numbers calculation is becoming a larger and larger component of both litigation and transactional work. And so the only ISO standard out there right now that helps deal with the storage of large volumes of data and the manipulation of numbers is probably the SQL standard. And this is a database architecture that exists at the back end of a lot of services that we use. My own company, Clio, for example, we store a lot of law firm information in SQL databases. And the reason it's important to have this is we do know that you'll be able to both access and manipulate this data in the future. And so if you're not looking at these standards and using them as the bedrock on which to build your producible work product, you're going to be putting yourself in a situation in which you cannot be meeting your obligations to either the clients or the tribunals before which you serve in the future. And so I think the takeaway here is that when evaluating technology now, lawyers must not just evaluate it on the efficiencies by which they will be gaining it, but they should also be evaluating it on the exit options that are presentable from it. So we've talked about some great uses for technology right now for lawyers, and the things that we can be doing with them to gain efficiencies in the criminal justice system, access to justice for lower income people. But as we pull that information in, we should definitely be taking a look at when can we exit that information, and can we do so in a way that meets our obligations as legal professionals. So that's my quick spiel. I want to thank everybody for letting me take time to do it. And if you have any questions, you can reach me at a variety of different ways, including my email, Twitter, and LinkedIn. And I'm happy to be carrying this forward because I'm not seeing a lot of discussion either in both big law or tiny law talk about the idea of longevity in legal technology as well. So I'll turn off the screen and pass it back to my handsome mug and see if there are any questions.
Thanks, Joshua. I think that's a wake-up call to a lot of us in this room, both practitioners and soon-to-be practitioners. I should also tell, by the way, I just started following Joshua on Twitter. It's a great resource. Highly recommend.
Oh, thank you very much.
Sure. And students and I are also experimenting with his Go Clio law firm management tool. So.
That's right. Thank you. Yeah, I hope that's going well. If there's any questions, let me know how I can help.
Thanks, Joshua.
Any questions from the audience on picking technology? The average lawyer tends to practice till about age 72. Are you picking tools today that will support you in that?
We have time for one question. I see a hand. First hand, that's where we go.
I'm just wondering if you have any suggestions for batch conversions if you have a whole bunch of files that are already in doc format or something like that, if you have any software recommendations.
Actually, I don't. That's part of the problem. So we have entire law firms that are locked into WordPerfect because that's what they bought in the 80s. And they're having to go through a manual conversion process with a lot of the formatting no longer being preserved. So I think what you're going to have to do is take a look at services out there that are already doing batch conversions for archival purposes, usually for museums and government services. And maybe we'll see law firms and a new business initiative come up on digital data preservation for the legal sphere.
So you know what I heard there? Joshua said problems. I heard opportunity.
Oh, good.
I heard a potential venture that explores that niche market, batch conversions for law firm documents. Okay. All right, so I think we're running behind, so I think we should have our alternative approaches to funding litigation crew come to the stage. Over the years, I know at least, I'm sure a lot of you have, my students and I have been exploring different